Hello, everyone. Good morning. I'm Delegate Janelle Wilkins, Chair of the Election Law Subcommittee, and joined by these wonderful subcommittee members. The date is February 29th, 2024, and we will now begin this meeting of the subcommittee. We have 4 bills that we are considering today, and you should have the amendments in your emails. Also, I think, Stan, there was one more that we're adding an amendment to on House Bill 641. If Isabella has that, she should send that out to the committee members by email.
Well, Madam Chair, perhaps I can read that one to the subcommittee since you're adopting one portion and not the whole thing.
Okay, we'll talk about that when it gets there. Okay, House Bill 14. We will take that bill up. This one is a departmental bill from the State Board of Elections. And actually, since the administrator is here, if you can share with the committee, with the subcommittee, the general explanation of your bill.
Sure. Thank you, Madam Chair. This bill does 3 things. One, it changes the report that we currently receive from the courts from basically individuals that are convicted of a felony to individuals that are convicted of a felony and sentenced to imprisonment with their commitment papers. This is the disqualifying event for voter registration, not felony. So the report that we were previously receiving was basically over-inclusive and would disenfranchise individuals. So this now corrects that in line with the voter registration laws that the General Assembly had passed, so that we will have, this will be effective, and we'll be able to use this report in order to clean our rolls. The other part is allowing local boards, directors to have access to public buildings for as an early voting center. This is a similar provision that they have for polling places. And there is an appeal process.
You can mute. Sorry, go ahead.
It's okay, no worries. Yeah, and then there's an appeal process just in case that the facility might have made arrangements or something, so that they would be able to explain why they cannot be used for that procedure there, and that the state board would adopt some regulations about how the appeal process would work. And we made it so that the timeline for them to get the buildings and appeal would all be done before that they have to submit their early voting plan to the state board for approval at the 6-month mark. So that's why it's 8 and 7 months ahead of schedule there. And then the last part is just basically allowing incumbent members of the Central Committee who want to run for re-election, if they are the chair, basically they can still act as the incumbent member of the Central Committee and run for re-election. It's just, the term treasurer should have been responsible officer way back when, and this just kind of corrects that one technical little fix there. But that is the 3 parts of the departmental bill, and thank you.
Thank you, Jared. Can you just explain a little bit more the Central Committee piece? And if someone's a candidate and they are running for a Central Committee to return to the Central Committee, there were restrictions on what kind of office they could hold. That's the one part that I think we want to just explain a little bit more.
Sure. It's a little bit of a, it's more technical and in the weeds than anything else, but so candidates can only be you can't be a candidate and be basically a responsible officer for another political entity. And if I am a candidate for Central Committee and the chair of that Central Committee, technically speaking, I am I have control over an entity that is not either a slate or a candidate committee. And the law kind of prohibits that. We fixed it for treasurers so that an incumbent treasurer for a central committee would be able to run for re-election and still be a candidate on the ballot and have their own committee. We forgot to change it for chairs. So this basically, the term responsible officer includes both chair and treasurer. So this allows a current sitting incumbent of a central committee to run for re-election for the central committee and only for the central committee, and still not have to technically resign as the chair. Now, if the individual wants to run for, say, delegate or a county office or any other office, they would have to then resign in order to file, because they would be a candidate for an office and still control the central committee's funds. So, and that's not permissible, because you can't be a candidate and control a campaign finance entity other than one of your own funds, because then you would be able to circumvent contribution limits and make expenditures from different entities.
Thank you for that explanation, Delegate Fair, then Delegate Feldmark.
Thank you so much, Madam Chair. Jared, just as a former member of the Central Committee, I just had we're basically already doing this, right? Central Committee members are elected to the Central Committee. They're serving as the chair of the Central Committee. They're running for re-election on their Central Committee. We're saying that we need a technical change to actually make that correct in our code. Is that a fair?
That's a fair assessment of everything. Yes.
Perfect. Thank you. I appreciate you taking the time to explain all that.
Delegate Feldmark.
Thank you, Madam Chair, and thank you, Mr. Demarinis, for the explanation. I just wanted to ask one clarifying question about the example you gave. If the chair of a central committee were to run for delegate, they would have to resign. They'd only have to resign their chairmanship, not resign from the central committee. That's
correct.
Different bill.
Yes.
Okay, great. Thank you.
Yes.
Wonderful. Well, there are amendments, and Stan, if you can share the amendments, which the committee should have received.
Sure, Madam Chair. So the first amendment is the change in the language about the reports on felony convictions. So it's the new language is that the person has been convicted of a felony and sentenced to imprisonment with commitment papers. So that's a more precise and accurate definition of the information that's needed. And then the other part of the amendments sets up the appeals process. If a public building is chosen and the public official responsible for the building that wants to contest the availability of the building, then there's an appeals process, first with the local board, and then if they're unhappy with the decision at the local board level, to the state board.
All right, thank you, Stan. And Jared, around the commitment papers and having a felony, the distinction that you're making in terms of the data that you're currently receiving versus what you actually need is that it's not that someone has a felony, but it's their incarceration that determines their ineligibility to vote. Is that correct? You're on mute.
So yes, it's both factors. It's a two-factor threshold. So you have to be convicted of a felony and be incarcerated in order to not be able to be a registered voter. So now this would allow us to have the right list.
Great. Well, sounds like some technical fixes for the most part. How about we go ahead and adopt the amendments? If I can have a motion.
So move, Madam Chair, to adopt the amendments.
Second.
Okay, it's been moved and properly seconded. Any further discussions on the amendments? Okay, seeing none, all those in favor of the amendments to House Bill 14, say aye or raise your hand. Any opposed to the amendments? The ayes have it, and we are now on the bill as amended. I'd like to entertain a motion and then we'll have further discussion on it.
Move favorable.
All right, a second.
Second.
All right, on the bill as amended, any further discussion? Seeing none, all those in favor of House Bill 14 as amended, raise your hand or say aye. Any opposed? The ayes have it. And House Bill 14 moves forward favorable as amended. All right, that one's out of here. We'll move to House Bill 700, Election Law Judges Revisions. This bill makes several revisions to our process when it comes to election judges. It clarifies that a state employee who wants to be an election judge, it adds a county employee for them to also be able to take administrative leave. I believe the state employees already can. This adds the county employees for them to take administrative leave as well as get our election law judge compensation that we already previously have in effect if they would like to be an election judge. It also requires SBE to streamline and reduce the forms required to be an election judge. And it clarifies the definition of when we passed legislation last year to help incentivize those who previously were election judges. We said that if you were a past election judge, you basically get a financial bonus. And the bill clarifies that it can be in the immediately preceding gubernatorial or presidential election. I think that we do have at least one amendment on this, so why don't I just have Stan talk about amendments to this bill and then we'll get into more discussion.
Sure. So, yeah, so the amendment is actually to refine the definition of returning election judge, as Madam Chair described, so that it would be that they served in the immediately preceding presidential or gubernatorial election. Under the bill as introduced, it's just the immediately preceding election. So that's the amendment. And then there's one other part of the bill, which is that it would allow public school students to both receive service learning credit and get the election judge compensation. Currently, they can't get service learning credit for anything that they get paid for.
Thank you, Stan. Delegate Miller.
Okay, sorry, couldn't find this button. What's the current age that election judges can be?
So they can be 16, and then there's also a page program for 14 and 15-year-olds.
But
Okay,
the
and
pages are
then
not paid.
the pages are not paid. Okay, and then do they get, does this come as an excused absence for them? I guess it's usually they have off, unless it's like a city one or something. This is only the presidential and gubernatorial, you said. So they should have the day off.
Yeah, I think election day they do. I'm sorry.
No, you're fine. I was just thinking through my head. Okay. And then this is shall, for the county, we're doing it as a shall receive for the compensation and using the administrative leave.
Yes.
Okay, so that means they wouldn't administrative leave. You'll have to help me on this one because I'm not as familiar with it. What does that mean as far as like vacation or, just taking time off? So administrative leave is something different.
I think it's just a label that they put on leave that's given for reasons other than, personal leave or sick leave or whatever. It's just another category. As a state employee, that's how it's used for our department.
Do we know that all counties have administrative leave?
I don't know that they do necessarily.
But
I
mean, I don't know if we have time to find that out, but because it's a shall thing, not a may thing. So does that mean they would have to institute administrative leave if they don't have it?
I I think the intent is just that they be given leave. I don't think that the label that the county puts on it is significant. And I would also add Mako did not oppose this provision.
Okay, I mean,
Raise any concerns about it.
okay, but then, and then that's administrative leave is paid leave?
Yes,
So they're getting paid plus then they get the compensation?
that's the current policy for state employees.
Okay. All right, you have to forgive me, I'm new at this. And then the other part, if you could, just quickly, where it says you may not require additional forms or documentation for election judges. What would that mean? Can you summarize what that issue would be?
Madam Chair, I'm sorry, Delegate Miller, could you help me by telling me what page and line items? I'm
Page-
struggling to follow your.
I'm sorry, and I talk quick. Sorry, Chris. Page number 3. And then kind of in the top of the page where it says number 2.
Thank you.
Line 5.
Thank you.
Mhm.
So the intent of that is just to try to make it standard, standardize the process of applying for and receiving compensation as an election judge, and trying to simplify it and make it less of a burden and less of a barrier to people stepping forward to do this. This doesn't prescribe exactly what would be required. That would be something that the state board would work with the local boards and with the county governments to figure out how best to do that.
Yeah, I'll add that the purpose of that section is that we want to streamline the whole purpose of this bill is to further our work with recruiting and retaining election judges. And we want to streamline the paperwork. So I think that one particular section is important, because if we're streamlining the paperwork and then the counties are adding more paperwork, we just want to make sure that with the intent of the bill is able to be followed.
Okay. All right. Thank you.
Delegate Roberts.
Okay. Oh, good. I'm not on mute already. No, well, honestly, I don't know if I was just going to just further, I was just gonna say, I know in Prince George's County, administrative leave is just leave that does not count against your annual leave and sick leave. But I would suspect that all the counties do have it. And I just want to clarify that the language that we're talking about streamlining the process for is for returning election judges only, but only if they served in the previous one, not previous ones from the past, right?
So certainly the provision of the bill having to do with returning election judges is about just refining who is a returning election judge for purposes of getting that extra $100 compensation. So that's the part. The rest of the bill applies to election judges generally.
Okay.
And with the amendments, the way that returning election judges is defined is you have to have served either in the immediately preceding presidential or the immediately preceding gubernatorial election.
Okay.
So I hope that helps.
Okay. And so they're getting an additional 100 in addition to the 250.
That's right. And that's under the bill that passed last year.
Okay.
Yeah, so we're just defining what we mean when we say a returning election judge. We are just defining what we mean by returning. You had to have done the very last election, basically.
Right. Okay.
Not 5 elections ago, but the last election.
Okay. I didn't know that people under 18 could serve as an election judge, but that's great. That's great.
We're training them up young.
That's right.
Awesome. Well, why don't we go ahead and adopt the amendments? May I have a motion?
Move favorable.
Second.
Thank you. All right, the amendments have been moved and seconded. Any further discussion on the amendments? All right, seeing none, all those in favor of the amendments to House Bill 700, say aye or raise your hand. Any opposed? All right, the ayes have it. We have amended House Bill 700. Now on the bill as amended, let's entertain a motion and then we'll do further discussion.
Move favorable.
All right, a
Second.
second. All right, House Bill 700 has been, as amended, has been moved and properly seconded. Any further discussion on the bill? Seeing none, all those in favor of House Bill 700 as amended, raise your hand or say aye. All right, any opposed? All right, one in opposition, Delegate Miller. The ayes have it. House Bill 700 as amended will move forward from our subcommittee, favorable as amended. All right, moving on to House Bill 641, curbside voting. This bill requires that each Board of Elections would designate a location for curbside voting, which would allow a voter to vote outside at a location. Under the bill, though, it would basically ensure that during early voting that there's one location during early voting that would have curbside voting, and that during the actual election day, during the election day, the local Board of Elections would be the primary location for curbside voting if it's not practical for it to be the local Board of Elections, and they can designate another location. The bill does also have requirements around making sure that the location for curbside voting is accessible, that to the extent possible, there's public transportation access, and just so on and so forth in terms of accessibility. Delegate Griffith, I saw your hand first. Oh, actually, let me just mention the amendments really quick. Stan, can you share the amendment to the bill?
Sure, Madam Chair. Let me just pull it up. So this would be on page 4, after line 14. We're going to insert the following sentence. If the voter chooses to vote using a ballot marking device, an election judge shall bring a ballot marking device outside to the voter.
So this is just making it explicit that the intention is that the voter is able to vote with the ballot marking device outside. So that's just, it's implied, but we just wanted to make that explicit. So that's that amendment. And as you all know, if you remember the hearing on this, the whole purpose of this bill is particularly for people with disabilities, including people who have limited or no sight, that they have an opportunity to be able to vote their ballot on the ballot marking device in a way that is more accessible for them. Delegate Griffith.
Thank you, Madam Chair. And my question still kind of remains from the bill here, and I love the bill, support the bill. I'm just trying to really wrap my head around the implementation when it comes to electioneering, right? Whether it be somebody sitting outside the entire time, and can you electioneer when no one's at that spot and not when someone's gone? Like, I'm just trying to, is it a designated spot, or we're going to put up a little cubby? I mean, I'm just really trying to wrap my brain around how that would work, because we've already interfered with some of the electioneering opportunities around the drop boxes, and this creates another layer of that. So I'm just trying to, if somebody could help me understand that a little bit, I'd be grateful.
I can just say that the bill doesn't address electioneering boundaries, but it does authorize the state board to adopt regulations, and I believe the state board would determine the electioneering boundaries. That I don't know if Madam Chair or Jared has something to say on that.
Let's see if Jared can add to that, Mr. Demarinis.
All right, thank you, Madam Chair. Yes, we would extend the no electioneering zone during this area here, because I mean, this is where a person is voting, and so that facility, this person is casting a ballot. You can't have a person walk up to the car and knock on the window and hand literature at the time there. So the no electioneering zone would be extended for that, where the voting would take place, not where the cars are or anything like that. But so if it's, luckily this first iteration of this bill here is with the election board offices. So, it would just be, I would say, out the front door or right in front of that. And so the expansion of the no electioneering zone, I don't think it would be overly expansive, but it would push it back a little bit based upon this is the location of where voting would occur, and that bubble would start from there.
I mean, is there a chance we could put some guidance to try, that would advise to, and I'm not trying to stop the bill because I love the bill, obviously, but to give some guidance to the extent practicable to, have it as close to the front entrance as possible. And that's not only for electioneering, but also for the workers to be able to come out and very easily, receive the ballot and things of that nature. So there's a practical application to it on both sides. Is there some provision we can put in the bill just to shore that language up to make sure that the will of the General Assembly is extended to the election board?
Delegate Griffith, I think I'm hearing two things, so if you can clarify. On one hand, I'm hearing you talk about electioneering specifically, and then I'm also hearing wanting to make sure that the location is as close to the door as possible. I don't know if those are two related or two different things. So can you clarify?
Same. They're the same thing. Two different reasons for the same. One reason for the workers to be able as close to the door as possible, be able to access the voters, and two, if we keep it as close to the front door as possible, we'll have a minimal effect on electioneering.
So,
Jared, I don't know what your thoughts are on that.
Stan, I guess we can say that that the electioneering zone for a polling place or for this will not expand from the original designation, so that it doesn't push the bubble out, but because if it's already by the door, it would be in the 100-foot zone anyway, is what I'm thinking. So it's kind of, so right, like, because you start the electioneering zone at the front entrance and then go out 100 feet or, except in Montgomery. So this would only, I mean, in theory, only push it out another, where the curb is or something like that. So it doesn't necessarily, it might expand it by like 10, 15 feet or 20 feet. That's about it.
And it seems like there would need to be flexibility depending on the site.
Yeah.
You might, the curbside location might be some distance from the actual polling place. And in fact, the curbside location could be a standalone. It wouldn't necessarily have to be at a polling place. And that might even be desirable, like if there's a large parking lot that would be particularly good for this. So it seems like there might be a need for flexibility, but.
Well, that's why I said to the extent possible or the extent practical. I mean, understanding not everything is even. So if it could at least have a language to the extent possible or whatever the appropriate language would be. So the guidance is to try to do it if possible, but obviously it's not going to be possible in all circumstances.
I was imagining that it's almost like a drive up, that for the most part, the voter wouldn't even have to get out of the car.
Yeah.
They would just kind of pull up. So I think that it being close to the door, I think that makes it really difficult though, Delegate, in terms of it being a drive up. If we're talking about it being close to.
Well, the curbside by the front door, the closest curbside to the front door.
Yeah, okay. I think with the electioneering issue, and I'd like to clarify with Mr. Demarinis and Mr. Ward, I do not want us to be in a situation where the electioneering boundaries are expanded. I think they're already challenging. And in Montgomery County, to my Montgomery County people that are listening, sometimes those lines are a little suspect now for us that are trying to electioneer. So I don't want us to be in a situation where local boards are expanding the boundaries arbitrarily and there's confusion around electioneering lines. So I wanted to clarify with you. You said something like it wouldn't expand by more than 15 feet or something like that. So there's possibly an expansion of the electioneering line.
Well, just like when we had it with the drop boxes, because this is a location where voting would occur, it would move the starting point of the circle to this. I think what we did with drop boxes then was we kind of said if it's within the circle, of the polling place or the location that's already there, it won't expand it beyond that. It's inside the basically the no electioneering zone bubble. I think we can kind of have the ability to adopt regulations to minimize the impact on the no electioneering zone with the placement of a curbside voting location, and kind of give us, I think we need to have some sort of flexibility here, because I don't think it's, if we say 100 feet or 20 feet or whatever, right, it's, each location, we have to look at it. It's something for the next election, with, where we're going to have it drive through and everything else. And like Madam Chair was mentioning, it could be a little bit further away. It could be a standalone. There's all these different complicated. So I think maybe just the ability to have this with, some flexibility, that we have regulations in place with the notion to not expand the no electioneering zone, but allow for a voter to vote in peace, would be probably the best solution.
And then so Madam Chair, would the language, like, to the extent practical or possible, would that be able to satisfy Mr. Barrett's concerns and our concerns as well?
I'm open to that. I think that we don't want to prescribe too much,
Right,
because we want them to find a location that works. But I do think our interest and intent from this conversation is that we do not want it to be in a way that expands the no electioneering zone too much. So maybe there is something about, to the extent is it practicable?
I've stopped even trying to say that word.
to that extent, to limit it to the extent, to as little extent as possible. I'll say that. I'll say it that way. So let's chew on that. Let's take some more hands. Let's chew on that for a little bit and come back to it. But that is a good point, Delegate Griffith. Thank you for bringing it up.
Thank you, Madam Chair.
I thought I saw Delegate Miller. You may have put your hand down. Delegate Roberts, and then Delegate Fair.
Yes, just to add to, I know we're gonna put that aside, but thinking about the restaurant comes to a designated parking spaces. And maybe I mean, this is just something to think about, maybe it can't be at all polling sites. They're only at certain, are they only going to be at certain, or are they going to be at all of them? What's the goal here?
Just one during early voting and one on election day.
So maybe they can, what they can do, or what you can do is pick a site where the parking spaces to the building are closer. I don't know if that's even, if it's possible, but maybe the parking spaces to the building are closer.
I think you may have froze. Is it just me? Okay. Well, Delegate Roberts, you froze. Oh, there you are. You froze for a second. So I don't think we heard your idea that you were sharing.
No, I was saying maybe we could just think about possibly picking locations that have like parking spaces that are closer to the door than others, and just like signs that would say curbside #1, like they do at the restaurants and things. Some that, I mean, that's just a suggestion, but that's not my question. My question is, I was reading the bill and I wanted to make sure, or I guess my question is, this bill is only for those who have disabilities, right? Because if people start doing drive-throughs, realizing that it's some drive-through and we can avoid standing in line, because I know I would do that, but you might want to kind of clarify that a little bit more. You could start creating a bottleneck when it comes to voting, and then it takes even longer for people who have disabilities to get to that voting. And then the other, okay, I already said it. That was my second part, was the curbside parking spaces.
The intent is for it to be more accessible for people with disabilities. However, legally, I don't believe that we can limit it to people with disabilities only, and then it gets a little bit challenging when people have to prove their disability, or do you have a disability, prove, so it's, I don't think it's going to be possible for legal reasons as well for us to limit it only. I agree with you. It could get to be a bottleneck if a lot of people want to do the drive-through election, but I think that at least to start, we're starting off with one to kind of try this out and see how it works. And I think that this committee can always come back. This doesn't go into effect for this election. But for the next one, we can always come back and determine if there's a great need and we can expand it. Mr. Demarinis or Stan, do you want to respond to that in terms of if we're able to limit it to people with disabilities?
I actually believe you could do it, and actually in other states they do place limits on who is eligible.
Oh, okay.
Yeah, and so it's a policy choice rather than a legal choice. But as I understand it, the way they implement it in other states, they're not like if they have limited eligibility, like based on age or disability or something like that, they don't turn anyone away who shows up asking for this service. They're not checking for eligibility, but they would say to the public, this is for these categories of voters.
Okay, so I stand corrected. We could do it, Delia Roberts. I mean, there's something that I'm interested in the committee's thoughts on it. There's something, Stan, how do they normally do it? They just ask, do you have a disability? Or do you have a reason to use it? Or how does it work?
No, not at all. From what I understand, it's just that, they would, in their communications with the public, they would say, these are the people who are eligible to use this service. But like I said, they do not screen anyone or check for anyone's eligibility when they show up. They just, if you show up and are in the curbside voting line, you're processed just like anyone else.
Okay, so let's add that as I don't want to add too many verbal amendments to the bill, but let's add that as a potential that basically that SBE should advertise this or share it as something that's specifically for people with disabilities. All right, I see some hands went down. Delegate Fair.
So to touch on that, and then I want to touch on the curbside piece, the electioneering line as well. But Jared, if you could help us, Mr. Demarinis, sorry, if you could help us with that question specifically. Like, we get the intent of this bill, right? If we go back to SBE with this, everybody understands what we're trying to get at here. Is this something that could be handled just through internal regulations without necessarily having to prescribe it directly in the bill, that the intent of the bill about the accessibility piece? Who are we encouraging to use this?
Well, I think that as Stan mentioned, like if you put it in law that it's accessible to a certain population or to the disabled community, we're not checking that, and our judges are not going to ask, what disability do you have in order to avail yourself of this process here. So just like you, so it could be your intent, but the practicality of it all will be, it will be open to everyone, because we're not going to, and we don't have a list of anybody who is disabled or have any sort of, to go forward with it. So
yeah, and so I guess the crux of my question is if we don't amend the bill to add that language in, SBE could on the back end handle the messaging around how this process is supposed to work when it comes to messaging to the general public. Again, understanding that we're going to accept anybody, as Stan said, they message to the public, but do you need us to prescribe that you need to message that to the public? Or would you rather just handle that on the back end through the process of through regulation and through the process of administering this bill?
I would maybe for messaging purposes there, if it would be it would be prescribed, it would be easier, because if we're going to say that this is something for the disabled community, it would be very difficult for me to say that if it's a general bill and saying that, oh, the interpretation or the intent, though not in the law, was that it was supposed to be for this community. For my messaging at that point there, it would just be a regular, and you have the ability to vote by curbside, because we wouldn't have any sort of legal standing to section that off.
Okay, that's good to know. Thank you for that clarity. And then just to touch briefly, Madam Chair, on the difference between, I think in my head, the difference between curbside voting, if absolutely to the extent practicable, make sure that it's inside, because we're only doing one location. I am sure that jurisdictions are going to take into consideration density, but also feasibility of each of these locations to get that curbside voting inside of the existing boundary. But the major difference between curbside voting and going inside and voting is there is a period of time when you are out of your car where you do not have a physical structure surrounding you to create a natural barrier between you and electioneering officials. When you drive up to a curbside, when you drive up to vote now today, you usually drive through the electioneers. However, once you get out of your car and you press a certain line, you are now standing where they can come straight to you, but there's a line that says you can no longer do that. The line already exists with the car itself. You are able to roll up your windows. You are able to block the electioneers from being able to directly connect with you, even if you're sitting in line waiting to curbside vote. I just want to mention that as we talk about what is practicable, that we give the flexibility for those individuals to recognize, like, in even the worst case scenario, there is still a natural barrier that exists for voters to be able to not be inundated by electioneers and still respect electioneers' rights, First Amendment rights, to be able to stand within a reasonable distance of the polling place. Thank you so much, Madam Chair.
Thank you. All right, Delegate Feldmark and then Delegate Miller. Actually, Delegate Miller, I think, had her hand up first, probably. No. Oh, go ahead, Delegate Feldmark.
Okay, well, I've put my hand up and down a few times in the course of this conversation, so I really appreciate the discussion. On the question of expressing the intent that this is meant to be an accommodation for individuals with disabilities, I do think that is important. That's certainly what our discussion has been. But looking at the bill, I think that should be made more explicit if that is our intent, because, we love our cars, right? And people will wait in the drive-through line at Starbucks 3 times longer than it would have taken them to go in, order, and get their coffee, right? So I really think if this is, and I fully understand the Board of Elections is not in a position to make any determinations about individuals' disabilities, and I'm not suggesting we do, but I do think there should at least be some level of self-regulation of, at least letting people know, hey, if you drive up here and don't need it for accessibility purposes, you're that guy, right? And so, and so if, understanding what Mr. Demarinis said, that if that's our intent, it would help to make that more explicit. I do think that's worth pursuing.
That makes sense, and that's helpful. Thank you, Delegate Feldmark. Delegate Miller.
Yes, and I agree with everything pretty much that's been said, so that's why my hand kept going up and down as well. But I would encourage us not to exclude age or look at the way other states have included age in the provision, because there's a lot of people who are older who don't consider themselves disabled, and so they might not see themselves in that category. And we've all seen them like have to stop halfway, and really having challenges getting into the polling places. Even in the way some of the buildings are designed are difficult for them to get in, that they may not realize. So just however we can capture that as well, I think would be beneficial.
Okay. Well, I'm interested in getting the will of the subcommittee. We do have 3 verbal amendments on the table. One, which I am hoping that we will adopt, is the one that we started off with, that's coming from the subcommittee that Stan mentioned, just clarifying that if a voter does want to use a ballot marking device, then the election judge will bring it outside, making that explicit. The second is around the issue of electioneering, wanting to limit to the extent practicable the impact on the electioneering line. And finally, our intent that this is to increase accessibility for those who need it. We can put in people with disabilities or whatever it is, but I think we all understand that we are wanting this to be something that is utilized by people who have accessibility challenges. So those are the three that are on the table. I want to get the comfort of the subcommittee if you're interested in voting these verbally and moving forward with the bill, or if you would feel more comfortable with holding it. So just wanted to check on that, on how people feel. Delia Fair.
Madam Chair, I think that there's broad consensus in this room that for all three of these amendments, and I think that we can trust the incredible Stan Ward to make sure that he adequately grasps everything that we're outlining here before we vote. So I'm comfortable making a motion to approve those amendments as outlined by yourself.
Second.
Thank you. All right, it's been moved and properly seconded. Any additional discussion on these amendments? Seeing none, all those in favor of the subcommittee's amendments, which were great ideas from Delegate Roberts, Delegate Griffith, and one from the sponsor as well. All those in favor say aye. Or raise your hand. Any opposed? All right, the ayes have it, and we've adopted these amendments. We'll make sure that everyone gets a physical copy once Stan has them drafted up. On the bill as amended, may I have a motion?
Move favorable.
Second.
All right, it's been moved and properly seconded. House Bill 641 as amended. Any further discussion? Seeing none, all those in favor of House Bill 641 as amended, please raise your hand or say aye. Okay, any opposed? All right. House Bill 641 moves forward, favorable. The last bill is an excellent, amazing, good bill with an awesome sponsor. House Bill 627. And this bill is simple in some ways in that we already have automatic voter registration currently. We do it through the Health Benefits Exchange. We do it through the MVA. It's very successful. This bill also adds the Department of Public Safety and Correctional Services to be an automatic voter registration agency, specifically upon the release of an individual, as we discussed earlier on another bill, after incarceration. Marylanders are eligible to vote, and the intent of this is to do a better job at getting them registered. Any discussion on the bill? All right, I'd like to entertain a motion. And this
Move
has no
favorable.
amendments, right, Stan? No amendments.
No amendments.
No amendments, okay.
Move favorable.
Second.
Any discussion on House Bill 627? All right, seeing no discussion, all those in favor of House Bill 627, raise your hand or say aye. All right, all those opposed? I won't take it personally. Delegate Griffith and Delegate Miller opposed. All right, this bill moves forward favorable. And that's all we have for today. This was such a great discussion, working together in a bipartisan fashion to improve our legislation. Isn't that democracy at work in Election Law Subcommittee? I love it. Well, thank you for your time, and I'll see everyone